Hello guys, and welcome to another episode of my lecture. This particular section discusses the indoor management rule under the Cama. But do not forget, when I was speaking about the indoor management rule under the common law, I told you that we have the constructive notice and we have the presumption of regularity under the common law, and I explained this using a lot of cases, starting from the English cases to the Australian cases to the Nigerian cases on this subject matter of indoor management rule, explaining constructive notice and presumption of regularity. I even showed you the 5 different exceptions that we had under the common law, but it is totally different under the Cama. That is the Companies and Allied Matters Act 2020, because under the Cama we do not have anything like the constructive notice anymore. Why did I say that? Let us read section 92 of the Companies and Allied Matters Act 2020. So according to section 92, it says, except as mentioned in section 223 of this act, regarding particulars in the register of particulars of charges, a person is not deemed to have knowledge of the contents of the memorandum and articles of a company or of any other particulars, document, or the content of documents merely because such particulars or documents are registered by commission or referred to in the particulars or documents so registered or are available for inspection at an office of the company. So this exemplifies what I'm talking about. There is no doctrine of constructive notice. If we look at other cases, those cases under the common law, you would see that the basis of presumption of regularity for them is the fact that they deem it fit that according to the articles of association, you have represented to third parties that this is how you want to run your company. Therefore, if you have made this representation in your articles or in your memorandum, we are deeming it fit that the third party have knowledge of that, and it is based on that knowledge that they have acted. It is going to be unfair to such third party if the court would hold that things are not done in accordance with the articles. You were the one that put your articles out. You were the one that told the third parties through your articles that this is how your company will be governed. This is what your company would do. This is how your company would act. These are the people that have delegated authority. These are the people that, you understand? You already said this is how the company would be. The third party saw the company's articles, saw the company's memorandum, relied on the memorandum when it entered into a contract or any other thing that it did with you. It is going to be unfair, according to the court, to say that things were not done in accordance, therefore the third party should bear liability. No. Things should have been done in accordance, and therefore the third party should not be liable. Do you understand that? But when we are interpreting this doctrine of constructive notice in line with Cama, Cama has totally abolished the doctrine of constructive notice. What then would that mean to say that the Cama has abolished the doctrine of constructive notice? Does it therefore affect the presumption of regularity? Did Cama abolish the presumption of regularity as well? These are the things that I'll be discussing in the next series of videos. But in my next video, I'll be talking about the presumption of regularity in the articles and memorandum. See you in my next class.